Then, Yusuf, my submission will be that we're ready to proceed and we're quite happy to proceed in this court. That provides that any court is a quality court, and this court has got the jurisdiction in terms of what we're asking for in terms of a remedy and also where the alleged offence took place. So I don't know if that's what the court wanted me to address.
I see. So we are all agreed this is the forum?
Yes, Your Worship.
And there's no referral to any other forum. The court will deal with the issues raised.
Yes, Your Worship.
I see. Counsel?
Yes, Your Worship. We've discussed that and a few other aspects, and we do agree that there is no alternative forum which would be more appropriate than this court indeed as a fact. So we're not asking for the matter to refer to any alternative forum or alternative dispute mechanism.
I see. All right. Now, having dealt with that aspect, obviously the next question would be, I see there is, are we dealing only with the merits first, or the totality of the complaint?
Your Worship, we would like us to deal with the totality of the complaint as it stands. We think it would be difficult to separate any one aspect out in respect of the complaint. We would like simply to be heard as a whole. Certainly what my learned friend and I have done is we've discussed what we think should happen in terms of the further conduct of the matter. I'm not sure the Worship received what style the replying affidavit on behalf of the applicant or the complainant. It's a rather long affidavit which is a mix between his argument and political rhetoric and sort of other things. We don't necessarily have it, although the rules of this court don't make provision for replying affidavit to be filed, we don't have a difficulty with that being admitted into evidence subject to our rights to argue that certain components of those that affidavit is irrelevant or shouldn't be taken into account. But certainly we don't have a difficulty with that being an affidavit before this court and before Your Worship. So we don't have a difficulty with that. We also don't seek to file any additional affidavits other than the affidavit which was being filed on behalf of the Iziko museums to date. So we think that certainly the papers as they stand are pretty much finalised. We also discussed whether the matter should be referred to oral evidence or not. I think we are in agreement that there isn't a need to have any oral evidence and the matter can be resolved on the affidavits as they stand, including the replying affidavit which is being filed. So we don't think that there is a need to refer the matter to any oral evidence or any additional evidence to be obtained. I think we're both in agreement on that.
I see.
And Your Worship, that obviously then deals with part of the requests which Your Worship delivered and indicated that we should be prepared to respond to. The point 2.2 of that request was whether about the conduct of the proceedings referred to oral evidence. In light of that, it perhaps makes life easier in the sense that we don't have to provide for discovery or order of witnesses or affidavits in respect of witnesses. So yes, in respect of that, we don't think that there needs to be any directions in respect of oral evidence, because we don't think there is a need for that. In respect of Your Worship's requested 2.3 about how to resolve the matters, procedural matters in the interest of justice, we think that really not much more is required. What we had in mind, Your Worship, is that we present some written arguments and heads of argument, and then in the date agreeable to Your Worship, we come back and we then argue the matter and make our submissions based on those written arguments. Certainly, if that pleases Your Worship, and if Your Worship is happy with it, that's how we would think the matter should be conducted.
Okay, for you?
Your Worship, my colleague has put to the court what we agreed, and I consent to that, Your Worship, and my suggestion is then that the court will allow us to exchange heads of argument, closing argument, and then the court can indicate when the court will be ready to hear us. Your Worship, as it stands, I'm ready to hand up my heads today and give my colleague my heads as well, and then we can allow him maybe 7 days if that would be suitable for them to reply, and then the court can indicate when the court will. And then all that needs to be remains is for us to argue.
I see.
Just in respect of the time period for heads, because of all the holidays and school holidays, also trials starting at the end of this month, I would ask for a little bit longer, obviously depending on what Your Worship directs and when Your Worship can perhaps hear argument, I would like a little bit longer to prepare my head, and if your worship would allow me that. But certainly what I had in mind is that if your worship could indicate the date on which your worship could hear the matter, we could perhaps work back from there and simply make some appropriate time periods which would give us sufficient time to prepare our argument and heads of argument.
It would appear to me from what I hear from the parties that because look, I don't want to sit in a situation where each party had its own understanding about what was agreed upon.
Yes.
All right. I understand the parties to be saying that there is an agreement that we deal with the matter on the papers as filed, that the affidavits are sufficient.
Yes.
But I also understand the respondent to be saying that there are portions of the replying affidavit that, in the view of the respondent, should not be allowed into the proceedings. Is it also agreed that these aspects will be dealt with in the heads of agreement?
We haven't specifically discussed that, Your Worship, but certainly from my perspective, yes, that's something we can deal with. It's about the relevance of certain evidence and interpretations of the work which is in question, which we say doesn't really take it much further, because certainly it's Your Worship's interpretation of it which matters, not what other people may think it says. But certainly there also sort of argumentative portions which of that affidavit which should rather be placed in heads of argument as opposed to an affidavit. I don't think there'll be any need to strike those out as such, but I simply just want to reserve the respondent's rights to say that certain aspects of that affidavit are irrelevant or unnecessary. But I certainly, from my perspective, think that could be dealt with in the heads of argument or indeed in the oral argument.
I see. Do you have any comment there too?
No, Your Worship, I agree that whenever the respondent finds it relevant, they can argue that on the day.
All right.
Thank you.
What days do you have in mind?
Certainly, Your Worship, I was thinking somewhere towards the middle of May, or certainly in Your Worship's hands in respect to the dates.
Maybe 15 May, Your Worship.
That's a Monday.
Yes, Your Worship.
Is that suitable for you, Council?
Yes, Your Worship. It might, perhaps later in that week, but certainly I'm available.
Maybe the 19th will be suitable, that's Friday.
That's also suitable for me, Your Worship.
I see. So this is the date of the hearing of the arguments.
Yes, Your Worship.
Yes, Your Worship.
And working from there backwards. You say, Council, you're ready to submit your heads to?
Your Worship, can I hand mine up and also include these? Thank you, Your Worship. And then maybe can I ask for the 1st of May for a response, Your Worship?
That's a holiday. I prefer the 5th of May, giving the parties 2 weeks to digest my heads. So obviously April is a difficult month with all the holidays and my commitment station.
5th of May, September.
So the 5th of May, the respondent will file their head.
Yes. No, you wish can't compromise.
Nothing, thank you, Your Worship.
The matter is then postponed to the 19th of May for arguments and the submissions to be made by council on the papers, which is an understanding after the applicant has filed the heads of arguments today that the council will also file their written heads long before the 5th of May 2017.
That's a please.
Court, please.
What against?
All right, support.